as you can hopefully see from the screen, my name is Richard O'Sullivan, and I'm co-hosting today's webinar with Victoria Roberts. Victoria was described in the last edition of the Legal 500 as a most accomplished advocate who prepares all her cases with skill and care and cross-examines witnesses with precision. You can find other gushing tributes to Victoria on her profile page on our website. So if we begin, and I'm hoping, I don't know how this is done, but I'm hoping that you're now seeing a blue page which says special guardianship orders. I can't see it, but I'm hoping you can. And if I could just say, by way of introduction, as I'm sure you're all aware, we're now celebrating 15 years of special guardianship orders. It will stagger, I'm sure, all of you to learn that notwithstanding my boyish good looks, that for the first 5 years of my working life, I operated in a pre-SGO world. I'm also sure all of you will be aware of and have no doubt eagerly digested the Family Justice Council's Family Law Working Groups just published recommendations to achieve best practice in child protection and family justice systems, special guardianship orders. And just to once again big up my colleagues, the secretary of the working group is Coram's very own Alex Lang, who has also just taken on an editorial role with Hirschman and McFarlane. We will be talking more about the working group's paper later on, but if we could start with some basics. So Rakaya, hopefully you can now show everyone slide 2.
Okay.
Which should be headed the basics.
There we go.
I'm very grateful, thank you. You'll all know this, I'm sure. Special guardianship orders are available and can be made in both private and public law proceedings. And it's become the go-to order for securing kinship placements. If I could ask to move on to slide number 3, please. So in terms of a special guardianship order, and I appreciate that I'm telling you all stuff that you already know, the key part, it seems to me at the heart of a special guardianship order, is what is contained at section 14C, which confers on a special guardian parental responsibility for a child. But more importantly, and this is covered by 14CB, whilst the order is in place, the special guardian is entitled to exercise parental responsibility to the exclusion of any person with parental responsibility for the child, apart from, of course, another special guardian. We'll come back to 14CB in due course. Rakai, could I ask us if you could move us on to the next slide, please, which should be headed the basics continued.
Yep, we're on that page right now.
I'm grateful. Lawyers will notice identical language in section 14C, subsection 3, to that contained in section 13 of the Act, which deals with child arrangement orders. In fact, I think that's a like for like, it's a mirror duplication. You just simply swap child arrangement order for special guardianship order. However, there is one notable difference between the two, which is that a child arrangement order, a live with order, allows a parent to remove the child, the subject child, for up to a month from the jurisdiction without the permission of the court or the agreement of other parental responsibility holders. While section 14C4, and this is the footnote that you have, extends the duration that a special guardian can remove a child from the jurisdiction to up to 3 months. So there is a disparity there between what a special guardian can do and what a parent can do, a parent who has a child arrangement live with order, in favour of the special guardian. Rakai, could I ask you to move us on to slide number 5, please? Now, this slide highlights the duty on a special guardian to notify a parent of a child's death. So a rather bleak scenario, but I have to be honest that it's not something I'd have picked up on before. And those of you who find yourselves advising special guardians or prospective special guardians would perhaps be well just to flag this particular duty up with them. Hopefully it's a duty that never arises, but nonetheless it's one that's clearly a serious and important duty and should not be ignored. Could I ask that we move on to slide number 6? So, of course, underpinning the making of a special guardianship order is the hope that it will be an enduring order, that it will last for the duration of a child's minority, with the consequence that Parliament has made it much harder for a parent to undermine a placement protected by a special guardianship order with at least 2 permission hurdles, which are contained at section 10, subsection 7A of the Act and section 14D3 of the Act. Of course, on the flip side of that, one of the benefits, or often quoted benefits, of a special guardianship order as compared to, say, adoption, is that there's greater scope for a child to maintain a relationship with his or her birth parents, with the consequence, of course, that the permission requirement is not extended to a contact application. Could I ask Rakai to move us on to slide number 7, please? So the first point I make, slide number 7, is that, of course, when a special guardianship order is made, that has the effect of discharging any care order or indeed any contact order that's been made pursuant to section 34. And that is dealt with at section 91(5)(a) of the Act. Interestingly, perhaps not surprisingly, there is no equivalent provision to section 91(2) of the Act in respect of special guardianship orders. So, as I'm sure you'll be aware, the making of a care order will discharge a live with child arrangement order. It does not do the same with a special guardianship order. So the special guardianship order, unless it is discharged, will run in tandem with any care or interim care order made by the court. And it's important that we perhaps keep that in mind, given that sadly it's not rare for local authorities to issue, or it's not uncommon for local authorities to find themselves issuing a second set of proceedings in respect of a child.
Hello.
So, hello.
Hello. Hiya.
I'm not sure who that is. Rakai, help.
Thank you. Thank you.
Can we just ask that you put yourself on mute, please?
Thank you. Apologies. Yes, so the position of a special guardian, if the child becomes the subject of perhaps a second set of care proceedings, is protected in as much as they will continue to hold parental responsibility until such time that the court discharges the special guardianship order. Now, the rider to that, of course, is that whilst the care order is in place, the local authority has the power to determine the extent to which a special guardian may meet his or her parental responsibility for the looked after child. So ultimately, the parental responsibility that is bestowed on a local authority when a care order is made trumps the parental responsibility of a special guardian. If I could ask Rakaya to move us on to the next slide. And I think this is slide number 8, which has at the top SGOs and adoption. So, and I believe Victoria is going to tell us a little bit about this topic.
Thank you, Richard. Hopefully people can now hear me and possibly even see me. So I'm going to talk a little bit about SGOs versus adoption. And of course, as we all know, special guardianship orders were established to provide an alternative route to permanence for children other than adoption. And there are significant differences between the orders. But as the Public Law Working Group reminds us, the primary issue is very similar, which is namely meeting the needs, welfare and development of the child throughout their minority or beyond. As such, potential carers need to be thoroughly assessed to ensure they can meet the child's needs in the immediate childhood and through adolescence. There are, as we all know, far more special guardianship orders now made than placement orders, but it is worth remembering that adoption remains an option even in family placements. And I've given you the case reference there for Re-S. That was a case where a special guardianship order was made to foster carers, and the court held there was nothing in the statute limiting SGO or adoption to a particular set of circumstances. Each case will turn on its facts and what order better serves the welfare of the child, and the court could impose an SGO on an unwilling party. It's very clear that each case is decided on the application of the statutory provisions that best meets that child. And the statutory scheme for making SGOs was designed generally to allow unfettered access to the courts thereafter by parents in relation to all Section 8 orders. And so, of course, that's one of the real differences, is that post-adoption, adoption provides that permanency and that protection. The case of Rien was decided post-BS, and in that case, the child had quite very high level of special needs, and the father and paternal grandmother continued to have contact. The prospective adopters facilitated maternal sibling contact in any event, and the court held that in that case, a special guardianship, notwithstanding that level of contact, wouldn't meet the child's need for permanence throughout her life, as her needs were going to continue well beyond her 18th birthday, and she needed legal parents to continue to act for her, and a special guardianship couldn't do that. And the court held on that occasion that although special guardianship has the advantage of not severing that legal tie between the parents, in every other aspect it was unsatisfactory and inappropriate for N's needs. She needed security, trust and confidence, and she needs to be made a permanent legal member of her carer's family, so that they were fully and solely responsible for her needs. And Rien is an exceptional case. In many other scenarios where a child was having that level of contact and linked to birth family, it seems unlikely adoption would have been appropriate. For N, she was never going to understand the legal concept of adoption, but she did understand sort of being a member of her family, and it was overwhelmingly in her interest to be a full member of that family and have permanent and total stability. In Re-F 2015, it was decided that an SGO to foster carers was more appropriate. It was a disabled child. Child had contact with a great aunt. The placement wasn't a cultural match, and in that case, it was important to have an SGO rather than adoption, so that that direct access to the child's heritage through the great aunt would be maintained. In Re-AJ and Re-MJ, there was consideration of adoption in family placements. And again, these are pre-BS, but the court's reasoning, in my view, still applies. In Re-AJ, concerned placement of a baby, the court rejected the submission that special guardianship had effectively replaced adoption, where children were placed in their wider families, where there are some cases that it's more that there will be SGOs, and I think, as we all know, that's the vast majority. Each case turns on its fact, and there is a judicial discretion to be applied. In the case of Re-AJ, the AJ and his carers needed the assurance and security of knowing that it was an adoptive placement that couldn't be disturbed, there was a real risk of the parents seeking to disturb it and making applications, which they would have been able to do under an SGO. And so there was adoption was approved in that case. Re-AJ also has a helpful comparison table at the end of SGO versus adoption. Similarly, in Re-MJ, an SGO was insufficient to secure the placement. In Re-T 2017, there was a child, Liam, who had been living with maternal cousins, and it had a number of siblings. But actually, on that case, even though the younger children, or the elder children, maternal half-siblings, were under different orders, found that Liam, an 18-month-old, did need stability and did need the making of adoption order, notwithstanding the skewing of the legal relationship with his half-brothers that would cause. I think, Rakaya, can we move to the next slide, please? Thank you. It's just about the need for there to be a balance between, as we all know, just because it's not an adoptive case doesn't mean that Re-BS doesn't apply. The court needs to consider all the realistic options. And when looking at placement with family members, it's just a reminder that I think if we often go straight off from a CMH into, right, SGO assessment, is that the right thing to do? Because what we need to make sure is that the placement is right. And with an assessment, we shouldn't be ruling out a different order. For example, is this a case where it's a kinship carer, but it needs to be under a care order? Is it a child arrangements order? Is it an SGO? And actually there needs to be a holistic analysis on the facts of what order meets the child's best welfare. We'll move to the next one, please, McGrath. Going to move on to start talking about the lead-in to the Public Law Working Group report. I think many people will have seen the Nuffield research. They produced a report in March of last year. They've continued to do work about special guardianship, and a helpful updating document, Making Special Guardianship Work, came out earlier this month. There is a perception, certainly among some people working in our field, that SGOs are potentially risky placements. And the Nuffield research is quite helpful in looking at, are SGOs of themselves risky, or is it actually potentially our system where we have the pressure of 26 weeks, truncated assessments, and rushing placements to sort of fit in within that, that makes them risky. I think the risk has potentially arisen with some of the serious case reviews. There is the very tragic case of Cheyenne Downer from 2017, who was murdered very sadly by her special guardian. And when you look at that case and you look at the serious case review, it seems to me it's not the special guardianship was at fault, it was the way that placement, or the way our family court justice system made a special guardianship order. Cheyenne Downer had the most tenuous relationship to her special guardian. The guardian wasn't put forward by the parents. There were a number of red flags, not least about the carer's motivation, which seemed to be primarily about getting money for a car. The assessment was completed without DBS checks or a medical check. The assessment, I think, is striking in its superficiality. There was no assessment of the work of the child, that her placement was going to be with a non-relative, where there was no birth family contact plan. It was an uncontested final hearing, and there was no scrutiny. Essentially, it went through on the nod. Notably, there was no support plan, though the LA, I think, paid for the car, no supervision order. The LA prepared its closure notes on the day the child was placed and closed the case a week later. There was a plan for 3 visits over 6 weeks, and none took place. And so I think that's an example of where they go wrong. But when we actually look at the research that's being done, there are a huge amount of positives. The national study, I think, looked at 100,000 care cases. There is a significant rise in SGOs being made as the outcome. I think notably, although I think 17% of care cases had the SGO as an outcome, in which there was an application for an SGO in only 1% of those. One of the trends they've noticed is that an increasing trend to have supervision orders attached. I think that reached its peak, I think, at about 35% a few years ago, but it was the last stats I saw for 2016-17 still had 30%. What is interesting is that actually the risk of disruption and further care proceedings is relatively low, at 5%. I mean, it's higher than an adoptive placement, but it is lower than family placements that end up coming back into a second set of proceedings. I think that figure of 5% rises to 7% when there's been a supervision order attached. This may well be an underestimate because it's looking at a second set of care proceedings, whereas actually there may be more placement instability that doesn't come to the attention of local authorities, or where other applications are made in private law rather than it being a second set of care proceedings. Where they were doing with the assessment, they have looked at risk factors and what looks at disruption. I think I put them in the bullet point there. It is fairly predictable that the risk factors for disruption are placement of older children, placement of children who have emotional or behavioural difficulties, where there is a weaker existing relationship between child and the special guardian. Unrelated carers have a higher risk of disruption. I think that's, I think there is a sense that people who are related have that more of that perseverance, perhaps less willing to give up. And also a child who's experienced a number of placement moves before being placed with the special guardian increases the risk factors for disruption. The positives or the signs of success are where the child integrates well into the into their new carer's family, where the child has fewer emotional or behavioural difficulties. Crucially, where the special guardians feel well prepared, which I think is, I think lack of preparation is something that we see again and again. It's inconsistent in terms of whether there is training offered, whether the SGs really do have an understanding of what they're taking on, and sometimes it can be pretty woeful. A further concern is around whether there is support within the special guardian's family for that placement. So do they have resources, do they have a network? And if they're not, and particularly if it's a birth parent that's anti the placement, what does that mean for the special guardian? How does their role change within their own family network? And also, of course, contact, where that is good and positive, that supports the placement, and entirely predictably, when it's not good and doesn't support the placement, it makes it more difficult. The Nuffield did obtain quite a lot of views from special guardians. Unsurprisingly, many found the process, not least the process of being assessed, which is very intrusive, but the care proceedings themselves to be confusing and stressful. There is a lack of advice. As we all know, getting legal advice is very difficult, and local authorities pay for a couple of hours, but that's not nearly enough. And so if people aren't joined and aren't able to get legal aid, actually it's very difficult. Social work advice can also be limited. Many reported having feeling there was a limited amount of information made available to them about the child. And I think that's something, if there are reports about the child and that child's experiences, their trauma and their likely behaviour and likely needs, that really does need to be shared. Special guardians felt they hadn't been prepared. And then, of course, contact arrangements problematic and conflictual. And there's a sense that actually for special guardians, they're being asked to take on a more tricky role than adopters are. But I think that's the background really to what we see coming forward from the Public Law Working Group. Rakai, could you move to the next slide, please? So yes, so these are some of the issues I think we have been seeing crop up again and again in our cases. One issue when we are trying to get things done in 26 weeks and trying to identify carers is that our system puts the onus on parents to put forward these alternative carers. So they are the gatekeepers of the contact details. And often they are asked to prioritise who should be assessed or pick your best three. And that is simply daft, because these parents are often in care proceedings for a reason. They are not necessarily best placed to know who is going to be the best, who's going to be a runner. And actually it needs an awful lot of social work. It needs help, it needs proactive involvement, really pre-proceedings, but also to help families understand and look within themselves. I think the FGCs are highlighted later as being really crucial to this. But putting the onus on parents to put people forward is why we end up with somebody coming forward at week 20, which then brings all of the problems of extending the timetable. And as it is, trying to get assessments done within 26 weeks when assessment teams, as far as I can tell, are struggling. They don't have enough resources. And so, and the final point there is about sharing information. How often do we see it that Granny doesn't have insight into the risks? Well, Granny hasn't been told what the risks are. And ReVZ, which is set out a bit later in the slides as well, because it's really an international case, but it does highlight that if you're going to be criticising Granny for not understanding adverse pre-care experiences, surely you need to tell her that there have been those pre-care experiences and what that means. But as we know from, I put there about RES, which is from the Mumby case from 2014, when a special guardian is identified late in the day, you need to apply those factors. Are they a runner? Is further assessment necessary? And if you can't do that justly and fairly within 26 weeks, you need to extend the time. And move to the next slide, please. Oh, sorry, I've moved, but about providing information to prospective special guardians. One thing is about how we get around doing that. Often a parent doesn't consent to documents being shared. If that's the case, that needs to go back to the judge, and the judge needs to give the permission. You can't have a prospective special guardian who is otherwise looking like they're potentially a runner to be told, no, actually you can't look at the child and adolescent psych report that tells you all the crucial things you need to know about this child's trauma and this child's needs. If that is the case and you're sharing a psych report, can it be understood? They are impenetrable to many people. And so the assessor there needs to be an insistence from all of us that that assessment involves time spent with this prospective person, a person being assessed, going through that report, making sure they understand it, giving them time with it, letting them ask questions, because they don't have legal advice as a rule that the parents have the benefit of. And also, if we are not in that case, if it's a bit more simple, then use of danger statements, as some local authorities use with signs of safety work, can be really helpful. That just distills for the prospective carer, this is what we're worried about, and they can take it on board or not. But moving on to the public law working group, this was a huge piece of work that's been taken on, looking at sort of a really radical overhaul of public law child proceedings, sort of pre-issue and in court, with a goal to reducing the number of care proceedings. I think if people heard the President's speech to the ALC, I think October 2018, he really went through the concerns that our family justice system is just under incredible pressure, and how do we manage that. The interim report of the public law working group on SGOs came out last year. Their final report came out this month. And the overall tone of that report is to remind us that SGOs are private law orders. They're primarily made on application by those with whom the child has lived for 12 months, whether that's a foster carer or a family member. And I think those of us in public law, or who operate mostly in public law and care proceedings, tend to forget that, because we're seeing them sort of lumped in at the end, and child is going to move to auntie in a week or two. But actually they were not designed for that. They were designed with a view to the child having lived there for 12 months. And so the public law working group emphasis really is on the expectation of child and special guardian having lived together for a significant period before final orders. And they also really highlight the need for proper assessment and support. It's well worth a read. It's very readable, the working group document. They note the stress of care proceedings on special guardians, who are often thrown into the complexity of it all with no advice, no time to think or reflect. They also make the point that the government did change the regs a couple of years ago, and that following that, assessments really had to address the harm children have suffered, the risk of future harm to the child by parent, relatives or others, a description of that child, not just who they are, but their personality, their development, their behaviour, and their current and likely future needs, the nature of their current and past relationship with the special guardian, and the special guardian's parenting capacity, not just in a generic sense, but in terms of their understanding of and ability to meet this child's current and future needs, particularly needs arising from harm suffered, their understanding and ability to protect from risk, and their ability to raise the child until 18. And the working group considered that there was little evidence that those regulatory changes had made any difference to the assessments or the matters considered by the courts. I'm not sure what others think of that. I think they have a point. I think there are certainly lots of cases we still see where the SGO assessment is pretty simplistic. But I have had instances where a special guardianship assessor really has got to grips with what a child's needs are, has spent the time, has done a very thorough assessment, and has said, actually, this carer is excellent, but cannot meet this child's needs because of this child. I think so. There are instances where it works. I think of another case where the assessor just did the simplistic, oh no, very nice person, positive. But it was the allocated social worker who had considered the regulations and challenged that positive assessment on the three grounds of: one, not understanding the child's needs, the lack of a relationship with the child. And it was a very tenuous relationship. They'd never met, and I think it was the person being put forward was a friend of the paternal aunt, so it wasn't related, barely connected. And also on the grounds of the ability to care for the child until they were 18. It was a very young child, and the special guardian was older and had a number of health issues. So I think there are signs that the regulation and changes are getting through, but I think it's a lot more to be done. Can we move to the next slide, Coram? So the working group makes 4 recommendations for immediate change and 4 for longer term change. So in terms of immediate change, robust comprehensive assessments and support plans. The group expressed concern about the quality of the assessments and particularly quality of the support plans. They considered inadequate preparation, inadequate consideration of short and long-term support, that you end up with children and carers struggling to manage when actually the risks haven't been properly assessed. And that has very serious consequences, not just breakdown of placement, but also harm to that child, including physical harm. There is real variation in the quality of assessments. They also highlight that where assessments are being done by independent social workers, there needs to be clarity as to the standard of the assessment and what it's covering. And I think many of us will have seen cases where the ISW produces a report, but it's not an SGO assessment. It's a parenting assessment. The statutory checks aren't done, and it really doesn't go into the points that need to be covered about relationship that I've been through before. I got some feedback from a colleague who is a children's guardian and also works as an independent social worker doing these assessments, and their feedback was that they still feel there's a lack of robust consideration of a carer's ability to care throughout the child's minority, and a lack of appreciation of the impact of early childhood trauma on the child's behaviour and development, particularly into adolescence. And I think that's pretty fair. It's something that many of us see in our cases, and that has a long-term impact. The working group really highlights the provision of support services. Again, I think we will be coming back to, again, the issue of resources about that, where resources from the local authority to identify people, to devote resources to in-depth assessments, and then to develop support plans. Again, better training and preparation of special guardians, absolutely. Of course we want that, but how? There really should be no reason why a special guardian can't get foster carer training or prospective adopter type training, but we're often told, a computer says, no, that is not available to special guardians. So it's going to be a question of whether the public law working group recommendations filter down to the resource level. The issue of a child caring for, special guardian caring for the child on an interim basis is an interesting one. It must be right. Of course, it's better for them to have, for that to have taken place. Of course, it brings with it delay. It brings with it a potentially risky move if a child is moving potentially from a stable foster care placement to an interim placement with special guardian. The child isn't necessarily being told this is your permanent move, but still it needs to be done. The question is how. At the end of the working group, there is the best practice document, there is the best practice guidance, and the sub-appendix B looks at the options for how you would do that interim placement. So is it ICO and approval as a foster carer? When you run into the difficulties of, well, what if you can't get that person approved as a foster carer? Can you use Reg 24? Can you also use Section 38.6 placement there with it being an assessment? And finally, there is the option of placement under a child arrangements order. So that brings with it the disadvantages of the PR being shared only between parents and special guardian or prospective special guardian, and the local authority not sharing PR, not holding the ring, and also the loss of lax status, which can bring with it a loss of access to resources. The interesting point I think they make is a very clear steer that they expect to see a reduction in the use of supervision orders with special guardianship orders. The working group considered it to be a red flag, and it's the result, in their view, that the assessment or the support plan are not sufficiently clear, thorough or robust enough to give confidence that either the placement is in the child's welfare best interest, or that the support plan will meet the needs of that placement. They considered that a supervision order, the making of a supervision order, is likely to signify a lack of confidence in the making of an SGO at that time, and results from the inadequacy of the support and services provided. I think that's true. How often, particularly when you're looking at a child being placed in a different borough than the local authority doing the placing, and there is the squabbling as to what's in a supervision order support plan and what's in the SGO support plan. And really, it should all just be in the special guardianship support plan, because that's the plan. That's what that child needs. That's what that carer needs. And so they conclude that in their view, it will be a very small number indeed of cases where it's appropriate to make a supervision order alongside an SGO. They also stress the need, renewed emphasis on parental contact, because that's crucial. So often it's off you go, special guardian, you're now in charge of that. And that needs to be built in much more into special guardianship support plans in terms of how this is going to be managed, how it's going to be managed safely and in the child's interest. We can move to the next slide, Makaya. The further recommendations they make are for longer term change, review of the statutory framework, and that's really about where do we go? We need to have more analysis. Do you amend the fostering regs so that you can place with prospective carers on an interim basis as foster carers? Should there be an interim SGO? From my view, an SGO doesn't feel to me like an order that lends itself to being an interim or semi-permanent order, because the whole point of it is that it's permanent. But when you have adoption, you have the placement order first, and then the child lives with the prospective adopters, and then the adoption order. And so some sort of framework around that seems sensible. Of course, here we go, more duties on local authorities. Again, this is really about identifying carers. I think they look at the really important role of family group conferences, and that it's going to be more pressure on, not pressure, expectation, obligation on local authorities to do the digging around and finding potential carers. And then if they want it to be that there's the effort, there's lengthy assessments, but they are done of realistic people, and resources aren't wasted on lengthy assessments of those who aren't realistic carers. Of course, that does mean then proper viability assessments, not the rushed 10-minute phone call that says, oh, well, that's good enough, and now we'll expend a lot of resources on a full assessment. And then review of public funding for proposed special guardians and greater support for them. And again, we clearly need that. One thing I raise is whether we know that children who are adopted and like children who are lax get priority access to a number of services. Could that not be applied to special guardians? Same as, for example, adopters get adoption leave. There isn't statutory special guardian leave, and those are things that might be looked at. If you can do the next slide, Makaya. It's this is the best practice guidance in REPS. Called for the Family Justice Council to provide guidance. The appendix E at the back of the Public Law Working Group document provides that guidance. It builds on the interim guidance published last year. It's comprehensive. It's the recommendation by the working group is the President should issue it immediately. I'm not clear as when that is likely to be, but it is needed urgently. They stress that in terms of this guidance, every case still turns on its facts and is decided on its facts, but it is a very helpful piece of guidance. It's worth reviewing. It notes that the importance of pre-proceedings work. They stress there shouldn't be a cap on the number of potential carers being put forward, but that local authorities should be following the Family Rights Group guidance on viabilities to make sure that robust viability assessments are done to identify realistic people. And it sets out the need for a timetable or a plan where an interim placement with a proposed carer is endorsed by the court, and potentially up to 12 months. And I think that's the end of my slides for a bit. I'm going to hand back to Richard for the next slide.
Yes, Rukai, could I have the next slide, please? I'll come on to this in a moment. There's been some questions on the chat room. Hopefully everyone's now got the case that was being referred to in terms of imposing a special guardianship order on an unwilling, presumably family member. So that's there. I was also asked about the provisions in respect to the interaction between care orders and special guardianship orders, and the relevant provisions, if it helps, are section 91(5)(a). So that's the discharge of a care order by the making of a special guardianship order. And as I say, there's no equivalent provision to that within section 91, which is obviously the part of the Act which deals with discharge and the impact of orders on other orders. But to assist, just to confirm my view that it's perfectly possible to have both a special guardianship and a care order in play at the same time, I'd refer people to section 33, subsection 3 of the Act, which talks in terms of, whilst the care order is in place, the local authority designated that order has parental responsibility for the child and has the power to determine the extent to which a parent, guardian or special guardian of that child can exercise parental responsibility. So I hope that helps. Now, I am mindful of the time and we've got quite a lot to cover. What you have in front of you now is the second half of section 14A. So we're going back now to the Act and what it says about assessments. So you'll notice straight away, it's been there from the very start, the 3-month notice period. So that's subsection 7, and you'll see, of course, in subsection 8, that on receipt of notice, a local authority must provide a report in compliance with the provisions of subsection 8, which sets out what is to be investigated. Of course, an applicant can only give notice if he or she is entitled to make an application, or if the court has provided the applicant with leave to pursue such an application. This is where I've let you down, because I haven't included the first part or half of section 14A, and that's subsection 3. So in terms of who is entitled to apply for a special guardianship order without the leave provision, well, that's set out at subsection 5, which again you don't have, and that includes any guardian of a child, any person who is named in a child arrangement's live with order. It doesn't matter if that person is related to the child or not. Any individual named in section 10(5) of the Act. So that's any person with whom the child has lived with for a period of at least 3 years. Note that that is, though, contained or further defined in subsection 10 of section 10, the 3 years need not be continuous, but must not have begun more than 5 years before or ended more than 3 months before the making of the application. Any person who has obtained the permission of every person who has the benefit of a child arrangement live with order in respect to the child, so they can make an application without leave. If the child is looked after and the local authority have given consent, then again, an individual can apply for a special guardianship order. In a case where a child is neither looked after or the subject of a child arrangement live with order, then in those circumstances, an individual can apply without leave if he or she has obtained the consent of all those who hold parental responsibility for the child. A local authority foster carer with whom the child has been placed for at least a year preceding the date of application can apply without leave. A relative with whom the child has lived for a period of at least 1 year preceding the application, like a foster carer, can also apply without needing to satisfy or making an application for leave. So in summary, if you have a live with order and you're not a parent, you can apply. If you are a non-relative with no child arrangement order, you're looking at 3 years of combined care within a clearly defined window. If you're a relative and the child's been living with you, well, that has to be for a year. Likewise, a foster carer. And if the child is looked after, you can apply if the local authority agree you can. If the child is the subject of a child arrangement live with order, then you can do so with the consent of all those named in the order in terms of the child living with them, not simply contact. But in all other circumstances, sorry, I have forgotten, of course, if there's no child arrangement order and both parents consent, you can make the application if the child's not looked after. But otherwise, before you can make an application, under the Act, you are required to secure the court's permission to do so. And any person who requires permission of the court to apply for a special guardianship order cannot make an application for such an order or even give notice of his or her intention to do so as required under section 14A7 unless and until he or she has obtained the court's permission to so apply. And that's Birmingham City Council and our 2006 case, EWCA Civ 1748. Apologies for not including that in the slide. Moving on, under subsection 11, which you can see at the bottom of the page, and we'll all be familiar with this, I'm sure, a court cannot make a special guardianship order unless it has received a report dealing with those matters referred to in subsection 8 again, so what we would expect. But you'll note that subsection 8 refers specifically to a report or investigation undertaken by a local authority. Subsection 10 allows a local authority to delegate or commission, outsource that investigation, that report. So if the local authority wishes to employ an independent social worker to do the work, they're allowed to do so. I've always been amused by the language of subsection 9, which says that local authority may ask, or the court, sorry, may ask the local authority to conduct an investigation and prepare a report, and the local authority must do so. So it's a sort of mandatory request, though one wonders why they just don't say that explicitly, but there you go. However, it does seem to me that before a court can do so, make that request to a local authority, in terms of an application by an individual who is not entitled to apply as of right, therefore requires the court's leave to pursue an application, then the court is required to consider that application, or indeed the suggestion of a report. So if it's going to direct a report of its own motion for somebody who's not in the category of those who can apply as of right, and in my experience, the majority of special guardianship orders that are directed in care proceedings relate to people who do not fulfill the automatic or the entitled criteria, then it does seem to me that the court must look closely at the section 10.9 factors. Thank you, I'm grateful. So it seems if one looks at section 14A, there's a fairly clear explanation of who can apply for an SGO, how they should go about applying for it, and who is responsible for undertaking the necessary assessment. So you'll see at the top of this page, I pose, or the question is posed, is there scope within section 14A for the court to direct an independent social worker to undertake a special guardianship assessment? And my answer to that is, I don't think so. So if you're a local authority, the good news is that on my reading of section 14A, the multiple Part 25 applications that the court seems to entertain for independent social workers to undertake assessment of those who've been negatively assessed by a local authority, they cannot be entertained. The court has no power to appoint an independent social worker to do that. There's no equivalent provision to the provision that applies to local authorities. The bad news for local authorities of my reading of section 14A is that if a court decides that a relative or family member who is entitled to apply for an SGO but hasn't done so should be the subject of an SGO assessment, then the local authority, no matter what concerns it may have about that individual, cannot refuse the court's request. So you're saddled with it, no matter what your viability assessment says. And of course, the same is true, I suppose, of a family member who, or relative or friend who is not entitled without leave to do so. What local authorities should be reminding the court of, in my opinion, when confronted with that situation, is that before the court can exercise its powers, its request for a report, it needs to go through the section 10.9 factors. So could I ask us, I'm again mindful of the time, could I ask Rakai to move us on to the next slide, please? Which I think is one for Victoria, but I'm
it
going
is. Fine. No, I was only going to do this very briefly because I think COVID is what we're all dealing with. Hopefully it's a short-term issue, but I think, as the President reminds us, we have a long road ahead. And it's really just about thinking how we do assessments when we're in a lockdown or semi-lockdown environment. The public law cases are still expected to be completed in 26 weeks. And it's just that when those assessments are being done, particularly remote viability assessments, to think about what the weaknesses in that might be, what visual cues were missed, what was, if it's being done on Zoom, the assessor only sees what the person's wanted them to see and can't necessarily see if other people were around and how that might have impacted on somebody's ability to speak freely. But I don't know, Rich, if you want to say something else about that one.
No, I'm happy to move on to the next slide.
Okay, great. The next one is support plans, which I think I've already really talked about when going through the public law working group summaries, that really the expectations that these plans meet immediate needs and identify potential areas for help in the longer term, that carers need to go into this with their eyes open. It's not about just simply loving a child and being committed to them, because that actually can't fix all of the problems for a lot of the children that we're dealing with. There is a real lack of CAM support. How often are people told that they don't meet the threshold until that poor special guardian, that poor child, are bounced back into a second set of proceedings because that child is now beyond parental control. And really, with these support plans, there needs to be much greater scrutiny, in my view, not only by the people who are representing the special guardian, if the special guardian is lucky enough to get representation, but by the children's guardian. If the guardian is signing off on a plan for this child to live with the special guardians, they should be jumping up and down to make sure that the things that need to be in that plan are in there, and that the LA gets funding from its funding panel signed off before the court sort of simply makes that order and everyone wanders off into the sunset. But we can move on to the next slides, Rakaya. Yeah, and one more.
Right, okay, this is me. I'll be really quick. I'm mindful that I think all these slides will be available to you in due course, and it's almost 4 o'clock. So there are 2 cases that I would encourage you all to read if you haven't read them already, and I suspect you have. And it goes back to my point about the section 10.9 hurdle. They're both judgments, they're both judgments featuring Sir Ernest Ryder, who clearly has a very clear view on this. And I'm not going to take you through this slide here. You can look at it in your own time. I suspect it will ring a bell. But he is saying, in terms, what are you doing, courts? You know, there is a safeguard in section 10.9 that needs to be applied. And if it's not applied, you are denying the child, the court, particular safeguards, so effectively a filtering regime, and you're ordering all sorts of reports that you know, perhaps are not proceeding on an appropriate footing. I could ask you to turn to the next slide. And he followed that up in re-PS. And again, mindful of the time and the fact that this is a fairly well-known judgment, I'm not going to take you through this one again, but it makes the same point about section 10.9. And what amuses me a little bit about this one is clearly Sir Ernest is getting increasingly exasperated by the approach to special guardianship orders. And if you look at the bottom of paragraph 54, right at the bottom, oh, sorry, wrong slide. If you just go back, that's right. You'll see that he says, insofar as the judge indicated, and this was his Honour Judge Tolson, the Central Family Court and other local authorities, it had yet to come to terms with the guidance in Re-H, and that is about the need for this filter. So I'm going to stop there, I think, at this point. There are lots of other things that could be said about Re-PS, a case that has everything in it. But I will encourage you to read that in your own time if you haven't done so already, or just to remind yourself of what it says, because that started this whole review process, which has ended up in the most recent paper that, of course, Victoria has sort of summarised for you.
I've just seen, oh,
now,
sorry. I'm conscious of the time, and we promised we'd finish by 4. I think if people, we had some more slides around international placements and placements outside the jurisdiction, but I think that may well be a topic in itself and will take us well past what is a reasonable hour on a sunny afternoon. But I'm happy, if people are content with that, that Rakaya can share those slides, which include a few other slides about a case law update as well. So if people want to read them, they can. I'm happy to have any questions emailed to us or to have a chat with anybody that wants to. I can see there are some questions on the chat, Hazel, and about the support plans. I think generally, if I'm drafting orders, I provide that the assessment comes in with a support plan. I appreciate they do take time. Where a report is negative and it's not even going to be challenged, I think that may be a slightly different view, but often they are challenged. And where it is challenged, you do need to have that, you do, in my view, need to have the support plan there, because that's what the court is assessing. They need to look at a plan, and they can only make an order, an SGO, with the support plan and by approving that support plan. So they do, I'm afraid, need to be there. Richard is on mute. I don't know if he knows that.
Well, I'm happy to be on mute.
Yeah.
I'm not on mute anymore, I don't think.
No.
I think the other question that we haven't dealt with, I don't know if we have time to do so, is the question posed by Matt Matthew regarding, I think from memory, BAME representation. So in terms of the working paper, I can't speak for the composition of the working group, I'm afraid. But more generally, I guess it is an issue that requires much greater consideration in terms of the suitability of special guardians. And one would hope moving forward that that will be something that comes to the fore. I mean, I think there has been a tendency because of 26 weeks to rush through these assessments. And I think we've now passed that. But also there's perhaps been an understandable focus on trying to keep children in a family without really looking at their particular needs. And I've certainly seen some very odd sort of combinations of children and special guardians. I'm not saying that's inappropriate, but I think there is something that needs to be considered from my perspective moving forward in a way that perhaps it hasn't so far. So I think Matthew raises a good point.
Yeah, I agree. I think I was just having a quick look at the membership of the various subgroups, and I think clearly the working group had an awful lot of input from a whole range of people. I think it's generally a fair comment that the legal profession, particularly senior judiciary, is male, stale and pale. But actually, I think when this working group, I think, did involve a lot of people involved, and where I think actually the representation is most important is in speaking to special guardians on the ground. And I think the Nuffield, well, I'm assuming the Nuffield did that because they were talking to special guardians. It's about their experiences, and that's where I think it's so important to get the cultural aspects of how do individual or how do communities see special guardianship. Are there any particular needs that need to be considered in terms of children's identity and all of that sort of stuff? And hopefully I would expect the Nuffield to be drawing on that. But I agree, Matthew, we need to make sure that we're not just dealing with people that look like us or thinking everything's the same for everybody, when actually we need to make sure we have a diverse range of views.
I think that's probably
is that everything?
it now. I need to be somewhere else.
Right.
I don't know about Victoria. I suspect other people will be elsewhere. Thank you ever so much for joining us. I'm sorry we didn't cover everything that we wanted to do within the allotted time. Obviously I'd encourage you to keep coming along to these seminars. I think there's going to be a summer pause now, but I suspect Rakaya will be organising stuff for the autumn. So for those of you I don't see or indeed know particularly well, I hope you have a good summer and enjoy the new relaxation, if we can, for however long that lasts.